Gross misconduct. Two words that mean you can be turfed out of your job with no notice or compensation. Worse, you can be sacked for gross misconduct even when you're not at work if you're in what's called a work context, such as, say, an office Christmas party. But what do you need to do to fall into this category, and is there anything you can do to get your job back after your boss tells you to vacate the building or not to bother to come in tomorrow? Mirror Money spoke to employment law specialist Philip Pepper, partner at law firm Shakespeare Martineau, to understand the rules surrounding summary dismissal. Your rights if something goes missing after the Christmas party. Most of the time, no. You have an employment contract and that cuts both ways, giving you rights as well as responsibilities. Normally, if you're unfairly sacked, or aren't given enough warning, you can take your employer to court, or at least an employment tribunal. But sometimes they can get away with it. Especially if you are found guilty of gross misconduct. This is something so serious it goes outside of the contract, meaning you can be dismissed with immediate effect, Pepper told the Mirror. Pepper explained that this varies from firm to firm, but there are a series of offenses that almost always count. These are physical violence or bullying, theft, unlawful discrimination, causing loss or damage through negligence, serious health and safety violations, serious incapacity at work due to alcohol or drugs. There's a full list of the 12 factors on page 57 of this document. You can be fired for committing an act of gross misconduct even if you're not at work, but there are conditions. It has to be within a work context, explained Pepper. This means a work Christmas party or event would count. Offenses outside work contexts can count too, if there are legitimate implications for the business. Pepper gave the example of someone getting into a fight while wearing work uniform, that was captured on CCTV and shown on the news. However, if you're watching the football in a pub on the weekend, and are involved in a fracas with a colleague, that would not count as grounds for dismissal, Pepper added, although bosses would be wise to try and ensure it did not have a knock-on effect at work. Not quite. Your employer needs evidence to support the fact you've been found guilty of gross misconduct before they can turf you out. They also need to take any mitigating circumstances into account and generally look at length of service too. More than that, they have to follow a fair process in deciding to let you go, or you could have grounds for appeal. If you do appeal, the authorities will look at the process by which your bosses arrived at the decision to let you go. For example, did they conduct a thorough investigation and speak to the relevant witnesses? There might also be grounds for appeal if you've been sacked for something that many other people haven't been sacked for, despite the management knowing about it.